So I believe we can start. So Marcelo, the floor is yours.
Muchas gracias, Estefano. Bueno, queremos abrir primero con unas palabras de introducción. Queremos invitar al embajador Hugh Adsett, representante permanente de Canadá ante la Organización de Estados Americanos, a darnos la bienvenida. Muchas gracias, embajador.
Muchísimas gracias, and it's a pleasure to be here with you all this afternoon. I really value these opportunities, even when we can't do things in person, to have a chance to reach out, have a little bit of a conversation with colleagues, and to talk a little bit about what we're all trying to do together. Let me first start by thanking, of course, Synergía Initiatives for Human Rights and Stefano, the Executive Director, of course, for organizing this event today. And thank you very much also, Marcelo, for the kind introduction. As I say, it's nice to be here. The panelists, many of whom I have met in the past in one place or another. Good to see many of you here today as well. Of course, Roberta Clarke, Rapporteur on the Rights of LGBTI Persons of the Inter-American Commission on Human Rights, Alexus DeMarco, the Executive Director of the United Caribbean Trans Network, Rebeca Omaña Peñaloza, Coordinator of the Universal Civil Identity Program in the Americas, James Westmin, Lecturer at the University of West Indies, and Verónica Álvarez Nuñez, who's a consultant with the OAS. And I'm looking forward to this panel discussion. I'll turn my screen off at a certain point because there is something that is going to draw me away for part of the afternoon, but I'm going to try and catch as much of this as I can. I know you'll want to get into the details. Let me just speak a couple of minutes about Canada's interest in this issue and perhaps in the context of the OAS. I think you're probably quite familiar with the OAS as an organization, the premier multilateral organization in the region. Canada's membership is relatively new. We joined 32 years ago. And since we've joined, we've had a couple of issues of significant importance to us, particularly democracy and human rights. Those have been the bedrock of our engagement in the OAS. We have for a number of years now been strongly advocating in support of the rights of LGBTI persons at home and abroad. And we've recognized in the current time with the pandemic that the pandemic has had a particular impact given inequalities that LGBTI persons have often been facing. We firmly believe that when everyone enjoys the same human rights and is able to participate equally in all aspects of their lives, each and every one of us, all of us, are much better for it. Maybe if I've got a moment, I could give a little bit of our history, because I think that maybe informs where we come from on these issues. Our progress, if we can say that, on LGBTI rights starts way back in the late 1960s as a result of advocacy by civil society, starting with the 1969 decriminalization of same-sex sexual activity between consenting adults. There's quite a bit left to do yet. There's more work, of course, still to be done, but we've taken a number of steps, including developing the first ever federal LGBTQ2 action plan, aiming to improve the social, economic, and health outcomes of LGBTQ2 people in Canada and globally. In 2017, the Government of Canada passed legislation to amend the Canada Human Rights Act to increase protections for transgender and other gender diverse persons. And our federal law now explicitly prohibits any discrimination, hate propaganda, or hate crime against Canadians based on gender identity or expression. We've also had provinces and territories, because in our system, the provinces and territories have a lot of responsibility, amending their legislation to facilitate the change of sex identification or sex designation on identity documents, including birth certificates for transgender individuals. Our Citizenship and Refugee Authority, the Immigration, Refugees and Citizenship Canada, no longer require applicants to supply proof of sex reassignment surgery in order to change sex designation on a certificate of citizenship. Clients who wish to change their sex designation on their citizenship certificate can submit other documentary evidence. This will ensure that applicants have access to a document that accurately reflects their gender identity. And we've also introduced an X option in Canadian passports for individuals who do not identify as male or female. The Prime Minister issued an apology in 2017 for past federal legislation, policies, and practices that facilitated systemic discrimination against and persecution of Canadians based on sexual orientation, gender identity, and gender expression. And recently, conversion therapy was made illegal in Canada, a major milestone in LGBTI rights. Parliamentarians came together and unanimously passed legislation to eradicate this harmful practice, and criminal code provisions came into effect in January. So that's the most recent development at home. We've also contributed as much as we can at the international level, trying to make sure that the issues of LGBTI rights and the need to engage in these efforts in multilateral fora continues to be a part of the work that we do as diplomats and the work that we do on promoting and protecting human rights. We advocate globally to eliminate laws and policies that discriminate against persons based on sexual orientation, gender identity or expression, sex characteristics as well, and work to combat all acts of violence targeted towards LGBTI persons. It's also an issue we raise regularly at the UN in the context of the UN's Human Rights Council. They have the Universal Periodic Review, and that's a spot where we raise this issue continuously. And we also continue to play a role in the Equal Rights Coalition. We were a co-chair at one time, I guess a former co-chair now, but we continue to play a role in promoting the full and equal enjoyment of rights by LGBTI persons worldwide. OAS in particular, also a key element in our approach. We will continue to work with OAS member states, and we've got a group, the OAS LGBTI Core Group, to advance these issues. We work with civil society organizations, again, Synergía, a really excellent partner for us in trying to work together to promote these issues. And today's event, which is I'm coming to now, is funded through a contribution that we've been able to make through a modest, small-scale program that we call the Canada Fund for Local Initiatives. And it's a program that provides small scale but high impact projects in more than 130 countries around the world. First time that the permanent mission to the OAS has had a fund of this nature. So this is our first year of doing something along these lines. Our embassies abroad are more perhaps familiar with this, but it was our first year to do this. And we issued a call for proposals that would aim to benefit people in 2 or more of the OAS member state countries, 24 OAS member state countries that are eligible, that are on the development assistance list. We received more than 100 applications, really good applications, and we could only choose 3. And one of those 3 was the project that we're discussing, or that we're here to discuss today, which is the Synergía Initiative for Human Rights Project, protecting and promoting the human rights of trans individuals in Anglophone and Francophone Caribbean through civil society and civil registries. So today is actually kind of a chance for us to celebrate a bit, to celebrate the translation and adaptation in the legal context of Caribbean countries of the guidelines for the implementation of the Inter-American Court of Human Rights Advisory Opinion 2417, which I know you know well, the one that's entitled Gender Identity, Equality, and Non-Discrimination with regards to same-sex couples. These are guidelines that are meant to encourage the adequate reflection of name, image, and gender of trans persons in civil registry documents. And I think the people who speak today will speak much more eloquently about the importance of this issue, but we recognize the significance and importance of this issue. And from our part, we're glad to be able to play a small but hopefully constructive role in the efforts that you're making. I'll finish with just one final thought. And it repeats what I said at the beginning. Diversity and inclusion are amongst our greatest strengths. And this is something I think that we truly believe. Everyone should be able to live a true and authentic life. No one should be subjected to discrimination or violence because of their sexual orientation. gender identity or expression or their sex characteristics. So thank you for giving us the chance to be here. Thank you for the work that has gone into this effort so far. And we're looking forward to seeing the outcomes of this project in the years ahead. Thank you very much.
Thank you very much, Ambassador Adsett. And before we give the floor to our wonderful panel, I want to highlight that there's been a project we have in Synergía together with PUICA has very nice for some time, 2 or 3 years, America, and thanks to this small grant that Ambassador described, that was very significant for us. We were able to extend this project to the English and French-speaking Caribbean, and so very much we thank you for this. And now I would like to give the floor to Rebeca Omaña Peñaloza from the Program of Civil Registries in the Americas. Rebeca, please, your place.
Thank you, Marcelo, and thank you, obviously, Synergía, for the invitation. I'm very sorry I will speak in Spanish because I was traveling until last night, and I'm so tired that I think my English will not be the best for all of you. But obviously, I can respond to any question or comment in English after. I have a very short presentation, so let me see if I can share here. 1 second. Yes, I hope it's ready. Soy Rebeca Omaña y soy la coordinadora del programa de universalización de la identidad civil en las Américas, y lo que voy a hacer es una pequeña presentación sobre un proyecto que venimos implementando de la mano con Synergía en los últimos 2 años, bueno, ya casi 3, desde el 2019, ya 3 años. Y un poco la idea es contarles, en principio, que el programa de universalización de la identidad civil de las Américas apoya a todos los Estados miembros de la OEA para buscar que todas las personas de la región tengan acceso a la identidad civil. El programa, desde su creación en el 2008, se ha concentrado en apoyar a las personas vulnerables, y hemos trabajado de esta manera con comunidades indígenas, comunidades afrodescendientes, personas que viven en áreas rurales, y desde el 2019 también hemos empezado a trabajar en el tema de identidad de género. Hemos trabajado en países de América Latina y del Caribe, en total en 19 Estados miembros de la OEA, y este es el primer proyecto que tenemos en el que nos hemos concentrado en el reconocimiento de la identidad de género autopercibida. Y quiero decirles brevemente por qué empezamos a trabajar en este tema. Es básicamente la coincidencia de varios aspectos. En principio, vino de un inicio de consultas por parte de los registros civiles, muy especialmente de América Latina, pero distintos registros civiles, acerca de la temática. Y nos empezaron a consultar al programa sobre la información que tenía, sobre cuáles eran las prácticas que existían para el reconocimiento de la identidad de género, en qué países de las Américas o fuera del continente. Esto se unió con el hecho de que la Corte Interamericana de Derechos Humanos publicara la opinión consultiva 2417, donde se hace referencia al programa base de nuestro trabajo. Al mismo tiempo ocurrió un acercamiento entre Synergía y PUICA, debo decir que un acercamiento muy importante y que vino muy especialmente de las personas colegas de Synergía que se acercaron al programa y nos plantearon la posibilidad de hacer un proyecto conjunto para trabajar sobre la temática, y se convirtió en la primera vez en que desde PUICA trabajamos en un proyecto directamente con sociedad civil desde la preparación, desde el diseño del proyecto y también en su implementación. Y hubo al mismo tiempo una cuarta coincidencia, que es el CLARCIEF, el Consejo Latinoamericano y del Caribe de Registro Civil, Identidad y Estadísticas Vitales, debido a que habían tantas preguntas de los registros civiles de la región. El CLARCIEF decidió, uno, traer el tema a las reuniones regionales para empezar a sensibilizar a sus miembros sobre la temática, y en segundo lugar se incorporó el tema del reconocimiento de la identidad de género a los grupos de trabajo del CLARCIEF que funcionan durante todo el año y en los cuales los registros civiles tratan las temáticas más importantes. Lo que hemos venido haciendo desde el 2019 hasta ahora es un proyecto que está centrado en tres elementos fundamentales. Un elemento de capacitación, un segundo de cooperación y asistencia técnica, y un tercer elemento que tiene que ver con la documentación de las prácticas existentes. En cuanto a la capacitación, hemos hecho varios tipos de capacitación. Por un lado, tuvimos un taller subregional para México, Centroamérica y la República Dominicana. También hemos hecho capacitaciones específicas para registros civiles a nivel nacional o local, como nos lo han solicitado. Este es el caso del gobierno del estado de Michoacán en México. Y hemos colaborado con contrapartes de la sociedad civil, como la Red Lag Trans, para participar en talleres de capacitación espejo para registros civiles y también para sociedad civil. Y lo que hacemos allí en estos talleres de capacitación es precisamente trabajar con las personas funcionarias de los registros para que entiendan cuáles son los conceptos fundamentales en las materias de reconocimiento de la identidad de género, cuál es el contenido de la opinión consultiva y cómo el contenido de la opinión consultiva tiene un impacto en los países y en los registros civiles y en las prácticas de los registros civiles. Hemos tenido conversatorios de personas trans con los registros para que expliquen a través de su propia experiencia, uno, cuáles son los retos del reconocimiento en los distintos países, y dos, cuál es el impacto del reconocimiento de la identidad de género en la vida de las personas, que es lo más importante para nosotros. Y también nos permite que sean espacios de colaboración, de cooperación, de intercambio entre los registros civiles para identificar cuáles son los retos que existen en común y de qué manera podemos trabajar hacia el futuro en esos retos. En segundo lugar, como les decía, tenemos un componente importante de cooperación y de asistencia técnica, y allí la OEA ha trabajado en dos formatos. Un formato es lo que nosotros llamamos cooperación entre pares, y esto es básicamente, muchas veces es difícil para una institución recibir comentarios o recomendaciones de alguien externo, pero es distinto cuando alguien que comparte nuestros propios retos analiza la información y nos da recomendaciones. Y eso es precisamente la cooperación entre pares a través del mecanismo de cooperación interamericano para la gestión pública. Es funcionarios de otros registros civiles que vienen a solicitud de un Estado miembro, en este caso, por ejemplo, el gobierno de México o el gobierno del Estado de Jalisco, también en México, para analizar una pregunta específica o un tema específico relacionado al reconocimiento de la identidad de género y dar recomendaciones al país que pueden ser implementadas. Por ejemplo, el Registro Nacional de las Personas, el RENAPO de México, nos pidió una ronda para que hiciéramos una revisión de sus prácticas a nivel federal y le diéramos recomendaciones, por ejemplo, sobre cómo utilizar la información en las bases de datos o en los códigos únicos de identificación que existen en los documentos de identidad. Todas estas recomendaciones se preparan por las personas que son invitadas a la ronda y luego se entregan a los registros civiles. También tenemos espacios de asistencia técnica directa, y este es el caso, por ejemplo, del gobierno del estado de Michoacán de Ocampo, también en México, que en este caso ya tenía un procedimiento de reconocimiento de la identidad de género, pero no tenía un manual de capacitación para que las personas funcionarias aplicaran el procedimiento y no tenían un protocolo de atención de las personas trans. Entonces, lo que hicimos fue con ellos desarrollar estos documentos, capacitar a más de 100 funcionarias y funcionarios y funcionarias de todo el estado de Michoacán y dejar esta documentación lista para que pueda ser utilizada por todas las personas funcionarias. La última cooperación técnica la estamos implementando en este momento y estamos haciendo un análisis de todo el marco legal que existe en Honduras como para darle una cooperación al Registro Nacional de las Personas y tratar de identificar si el registro puede hacer cambios o puede hacer nuevos procedimientos para el reconocimiento de la identidad de género. En el caso, por ejemplo, de Honduras, hoy en día se puede hacer la toma de la fotografía con la expresión de género de la persona, pero no se puede hacer nada más. No se puede hacer el cambio de género o sexo en el documento, en la cédula de identidad o en la partida de nacimiento, y no se puede hacer el cambio de nombre. Entonces, lo que estamos haciendo a solicitud de Honduras es hacer una revisión de todo el marco legal existente, desde la Constitución, pasando por las leyes de registro civil, por toda la normativa, para ver qué camino podría tomar el Registro Nacional de las Personas para tener una ley o un procedimiento de reconocimiento de la identidad de género. Finalmente, el último componente del proyecto es la documentación de prácticas, y para eso ya hablaba el embajador sobre una de las publicaciones que hicimos con Synergía. Hemos hecho, por un lado, estos lineamientos para la implementación de la opinión consultiva, y por otro lado, una publicación sobre el reconocimiento legal, las prácticas existentes para el reconocimiento legal de la identidad de género en las Américas. Este documento está también traducido ahora al inglés, incluye principalmente las experiencias de América Latina, pero creo que lo que nos trae esta contribución de Synergía y con el apoyo de la misión de Canadá y del gobierno de Canadá es que podamos tal vez ahora incorporar estas nuevas prácticas del Caribe a la documentación que ya tenemos y a una herramienta virtual que se encuentra en la página web del Clarke, y ahora se los voy a poner en el chat. Lamentablemente la herramienta solo la tenemos en español, pero esperemos que podamos más adelante conseguir financiamiento y poderla traducir al inglés para que las personas del Caribe y también de los Estados Unidos y de Canadá que estén interesados en el tema la puedan encontrar. Yo quiero terminar simplemente comentándoles qué es lo que creo yo que hemos logrado desde el 2019 hasta aquí, y es que hemos visto cómo los registros civiles están tomando medidas y cómo han habido cambios desde el 2019 hasta acá en muchas políticas, en procedimientos, en reglamentaciones. Hay lugares donde hace 3 años no existía nada y donde empezamos a ver que surgen procedimientos, que hay nuevas revisiones a los procedimientos existentes para mejorarlos, para hacerlos mejores y más accesibles a las personas. Hemos visto también que todas las personas que participan en los talleres, no solamente en talleres presenciales, sino en seminarios web que hemos tenido con Synergía durante estos años, vemos cómo hay una adquisición de conocimientos y hay sobre todo una sensibilización sobre la importancia del tratamiento de las personas que solicitan los procedimientos y cómo es importantísimo que las personas funcionarias públicas tengan como primer elemento la importancia del tratamiento adecuado, respetuoso y para brindar el mejor servicio a las personas que solicitan el reconocimiento de la identidad de género. Además, creo que es muy importante decir que se han abierto canales de intercambio entre los registros civiles y la sociedad civil. Hemos visto cómo de los talleres de capacitación, por ejemplo, han surgido posteriormente reuniones entre registros y la sociedad civil específica de cada país, y creo que eso es un elemento en el que nosotros esperamos seguir contribuyendo. Y finalmente, Finalmente, el impacto de la opinión consultiva, ¿no? Que para nosotros es muy claro cómo está transformando la forma de actuar de los registros civiles, y creo que el caso más reciente es, hay una sentencia de la Corte Interamericana en el caso Vicky Hernández y otras contra Honduras, que es un poco un catalizador para que ahora el gobierno de Honduras haya buscado el apoyo del programa de PUICA y de la OEA para tratar de apoyarlos precisamente en un procedimiento de reconocimiento que dé respuesta en parte a la sentencia de la Corte Interamericana. Entonces, la opinión consultiva definitivamente está teniendo un impacto que nosotros esperamos que siga existiendo y que podamos ver procedimientos, leyes que contribuyan a lograr la identidad de todas las personas en el hemisferio. Yo lo dejo por ahí. Aquí está igual, en cualquier caso, mi información de contacto. En la OEA estamos para apoyar a todos los Estados miembros que nos soliciten cooperación técnica y para dar cualquier enlace o entrada con instituciones, todo en la búsqueda de eso, de lograr la identidad civil y el reconocimiento de la identidad civil de todas las personas. Gracias.
Thank you very much, Rebecca. And I would like to say that this process has focused on 4 countries that were chosen because they are the Caribbean countries that are members of the CLARCE, which Rebecca already described to us. Those countries are Antigua and Barbuda, Belize, Haiti, and Jamaica. On the other hand, in order to carry out this work, we have had a valuable collaboration of 2 experts in the region. So to move forward, I will mention the 2 experts, Mr. Westmin James, lecturer at University of West Indies, and Verónica Álvarez Nuñez, consultant of the Organization of the American States. So to move forward with our panel, I would like to give the floor to Westmin James. Please, Westmin, it's your turn.
Hey, thank you very much. Is it possible to allow me to share my screen? All right. Thank you. So thank you very much for having me. So today, I would like to present a little bit on the 3 Caribbean, English-speaking Caribbean countries. That will be Antigua and Barbuda, Belize, and Jamaica. Just to give some background into when we're talking about the Caribbean, especially the English-speaking Caribbean, there are some slight differences where we come to Latin America and even Haiti in relation to its traditions, legal tradition, and its placement in the OAS. So I say sometimes I think I want to just to back up a bit to explain that sort of background so that everyone is aware. Now, the countries under study, of course, is Antigua and Barbuda, Belize, and Jamaica. And this is in a context in which most of the Caribbean countries, English-speaking Caribbean countries, still are in a state of criminalization of same-sex activity. Except for the Bahamas, which decriminalized same-sex activity in 1981, I believe, Belize through a court case, and Trinidad and Tobago as well. Now, there has been some movement in other countries in the Commonwealth Caribbean. They have cases that have been filed and at different stages, and it's believed to be favorable to removing these criminalized laws. That is a context in which the Caribbean, English-speaking Caribbean is, and that is different from the Latin American countries. Belize, sodomy was found unconstitutional in the case of Caleb Orozco and the Attorney General. And Belize's final appellate court, which is the Caribbean Court of Justice currently, had even recently had a case called McEwen and the Attorney General of Guyana, where they found aspects of laws of Guyana where it criminalized cross-dressing, as it's said, and that was found unconstitutional and in breach of Guyana's international obligations. So the context is that there is some movement in relation to this aspect of recognizing same-sex unions, same-sex relationships, as well as recognition of gender identity. Now, the CCJ as well, in a recent case from Barbados, had even found that under Barbados's rape legislation, that a man could rape a man. So there is, I'm saying, movement in the Caribbean in relation to that, to these aspects. Now, only 4 Caribbean countries or CARICOM countries, Barbados, Dominica, Grenada, and Jamaica, are parties to the American Convention. So when we are talking about those are most of the English-speaking Caribbean, and certainly the ones under study, except for Jamaica, are not party to the American Convention on Human Rights. There were only 2 CARICOM states, Trinidad and Tobago and Barbados, who had accepted the jurisdiction of the Inter-American Court on Human Rights. However, Trinidad and Tobago denounced the convention and jurisdiction of the court in 1998. So out of the countries under study, Jamaica is the only one who is a party to the American Convention on Human Rights. So while most states are not parties to the American Convention on Human Rights, they're certainly members of the OAS and are subject to the Declaration on the Rights and Duties of Man, and certainly under the purview of the Inter-American Commission on Human Rights. So, and of course, the declaration have now been certainly been interpreted by both the Commission and the court to be a source of international obligations on all OAS members, and the way in which they interpret the same declaration is very similar to what would happen in relation to the court. Besides that, the jurisprudence, the international human rights obligations of these member states under study involved other international human rights treaties where gender identity would be prohibited as a form of discrimination, as well as arguably the same sort of rights under the American Convention that can base a claim for gender identity and recognition. The only difference is that Belize is not a party to the Convention on Rights of Persons with Disability, but they are all members of the ICCPR, the Convention on all forms of discrimination against women, and the Convention on the Rights of the Child, where you can base some of the human rights obligations. The other difference, and I think what always happens, is that the English-speaking Caribbean has a different legal tradition to that of much of the Latin American countries. We certainly come from a common law tradition, while most of Latin American countries are civil law traditions. And what does that mean is that the way in which we see international human rights law and jurisprudence is that much different in the Caribbean as opposed to the others. We all have written constitutions which have fundamental rights provisions, but because of that English common law tradition, we still, or at least invoke the concept of dualism, that unincorporated treaties for which the American Convention on Human Rights is one, is not incorporated into the laws in these Caribbean countries, and as a result, they are not, or certainly not automatically incorporated. However, it doesn't mean that these Caribbean countries do not take it into account. We have the Caribbean tradition has used international human rights jurisprudence and conventions in different ways. One as an aid to interpretation of both the constitutional rights as well as certain legislation. It is used in cases of where there's ambiguity. The courts will interpret those laws and the constitutional provisions to be consistent with the state's international obligations if they can do so. And we have found that the courts have been using legitimate expectation as a way in which to ground some of constitutional rights for the use of, certainly to enforce unincorporated treaties. One slight difference is that the CCJ, which is the final appellate court for one of the jurisdictions, that is Belize, has, and in a case from Belize, have directly related this concept of protection of the law with the state's responsibility to comply with its international obligations. And they recognize that as a subset of the rule of law, a state you can breach a citizen's protection of the law rights if you do not comply with those international obligations and commitments, even though they have not incorporated into the domestic jurisdiction. So you see, the Caribbean Court of Justice is sort of opening that divide between dualism and monoism, and certainly really directly enforcing sometimes international human rights obligations, even though they are not incorporated into the domestic law. Now, the slight difference is that most of the countries in the Caribbean still have their final appellate court as the Judicial Committee of the Privy Council, which sits in the United Kingdom. And so 2 out of the 3 countries under study have the Privy Council as their final appellate court and bound by those decisions. And that court has not yet gone as far as the CCJ in relation to unincorporated international instruments. There's been movement in that direction. There have been recent jurisprudence from the Privy Council where they seem to be adopting and referring to the jurisprudence of the CCJ. And so this would be, certainly a positive move on that regard. So certainly in relation to this study, they included interviews and consulted through questionnaires and direct contact with local legal experts in the various jurisdictions, the civil society, the relevant registries in those jurisdictions, and certainly other civil registries that are LGBT friendly to garner the results for the report. So in relation to Antigua and Barbuda, which is West Sydney is the smallest of the 3 countries under consideration, gained its independence in 1981. And you would find that with, say for Jamaica, most of the other countries have gained their independence not so long ago. Its population is about 97,000. It's about 440 square miles. And it became a member of the OAS in December of 1981. In Antigua and Barbuda, a name change is possible. You can do so through the civil registry in Antigua and Barbuda. There has been recent amendments and legislation in Antigua and Barbuda to deal with name changes and other aspects and registration. And it's in the Civil Registration Vital Statistics Act of 2020. You have to, in this jurisdiction, they changed it from what would be for most of the other Caribbean countries, a deed poll, to one of an application to change name. The process is simply that you submit the application to the registrar of the civil registry in the prescribed form that is signed by the applicant as well as the commissioner of affidavit, or if the person is overseas, a notary public, to change their name that they have on their birth certificate. That has to accompany evidence of their current name as well as the payment of the prescribed fee. The registrar hears the application actually, and they can, if it is in certain circumstances, refer it to a judge in chambers of the High Court to determine. Usually that will happen where it involves a child or where there's no agreement and so on. But the registrar can hear and grant the application. They will enter it into the register of deeds and so on, and they can change the name on the birth certificate as well. So deed polls in what is the typical means of where we change names in the English-speaking Caribbean under this act is no longer valid, and you must make an application pursuant to the act for the change of name. Gender marker change is not possible in Antigua and Barbuda. And when you do your name change, you can change your name on your driver's license, your passports, and identification cards. The pictures on those relevant forms can be taken of as you wish in terms of your gender expression. And that is as much as far as they can go. They need to have legislative change in order to comply more certainly fully with the advisory opinion. In Belize, who gained independence in September of 1981, has a slightly bigger population, but their area size or the land mass is way bigger than all of the countries under consideration. It was a member since 1991 of the OAS. And in Belize, even though some persons thought, and I think some of the desk research showed that some persons at least believed that you couldn't change your name in Belize, but it is actually possible. It's done through the Belize Vital Statistics Unit, and it comes under the General Registry Act in Belize. The mechanism is via deed poll, and the process is certainly, there's a form that the civil registry or the general registry has that you can fill out with the relevant information, and you have to get it signed by the Justice of the Peace. And they, which is a very interesting aspect of them, is that they always want 2 original birth certificates and their valid form of identification, whether it be your passport or social security card. In Belize, there is no national identification card. Most persons use the social security card, which would be for national insurance purposes, as their identification card. So people say that, but it's actually not a national identification card. You file the relevant form with the Vital Statistics Unit and pay the prescribed fee. Thereafter, it will be stamped and entered into the Register of Deeds, the Registry of Deeds, and the person will receive a copy of that. The cost is about $11.50 US if you wish to get it in the normal time, which is standard time, which is 2 weeks. Or if you wish to have it expedited, you can receive it in 3 to 4 days for a payment of 72 Belize dollars or $36 US. Now, with that deed poll, you can change your name on your driver's license, your medical records, your passport, identification cards, and you can take those pictures in your in the manner in which you wish to for gender expression. Jamaica, on the other hand, has gained its independence in 1962, which is one of the first English-speaking Caribbean countries to gain its independence from Britain. Its population is about almost 3 million. It's about 10,000 square kilometers, and it's been a member since August of 1961. In Jamaica, too, you can change your name to accord with your gender expression. The department that deals with it is the Registrar's General Department. And I forgot to put in the legislation there, which is the Registry Act in Jamaica, and the mechanism is via deed poll. The process is a little bit more involved in Jamaica. You have to get a certified copy of your birth certificate or marriage certificate if you're changing as a result of marriage. You have to visit the registry department to have a copy of the deed poll drafted and vetted. You sign the new name in the presence of a Justice of the Peace. You take the document, which was drafted, to the stamp duty department and transfer tax department, where it will be legally stamped by a government agent for tax purposes or stamp duty purposes. When you return with the stamped document to the registry department for the recording of it, and then you would receive a certified document recording the name change with your birth certificate attached. Okay. The cost, again, depends on how fast you wish to have the process done. The express process is about 30 US, 7 to 10 days is about 20 US, ordinary is about 13 US. And for each document that you, extra document that you do, whether it be a marriage certificate or otherwise, is an extra 500 Jamaican dollars. The process can also be completed by an attorney on behalf of the individual, but it is not necessary to do so. And with that, you can change your name on your driver's license, your medical reports, passports, and identification cards. So that's in terms of the initial findings that we have found in relation to all three countries under study. None of the countries under study have legislation for gender recognition, and no cases as yet in the domestic arena has been filed in relation to the same. There is one case, but that is not from one of the countries under study, which is before the Inter-American Commission on Human Rights from Barbados, in relation to the buggery law in Barbados along with gender identity by a trans person.
Thank you very much. And now I would like to give the floor to Verónica. Verónica, the floor is yours.
Thank you very much, and thank you very much for the opportunity to present the case of Haiti. I will continue my presentation in Spanish too, so I apologize for that, but I will be available for questions at the end in English too. So I'm gonna try to share my screen now. And I hope you're seeing it now. En el caso específico de Haití, a mí me gustaría empezar un poquito comentando que si lo comparamos especialmente con otros países de la región en América Latina, digamos, las brechas en la identificación en otros países de América Latina están concentradas en poblaciones muy específicas, algunas de ellas las que mencionaba Rebeca, que tienen que ver con, por ejemplo, poblaciones indígenas, o poblaciones afrodescendientes, o poblaciones que viven en zonas rurales un poco alejadas, y dentro de esos grupos vulnerables también encontrábamos la población trans, ¿no? Pero son brechas mucho más pequeñitas, entonces sí los problemas de cobertura de la identificación tienen características muy específicas de esas poblaciones, entonces las soluciones van muy dirigidas a estas poblaciones específicamente. En el caso del contexto de la identificación en Haití, según datos, por ejemplo, de 2017, entre un 20 y un 28% de la población adulta no cuenta hoy en día con una identificación. Entonces estamos hablando de brechas de cobertura de la identificación que son mayores que en otros casos de la región, y esto nos pone en un escenario en el que podemos ver que algunos de los desafíos que tienen que ver con la identificación en el país son más amplios que quizás en otros lugares de la región y no afectan tan específicamente a algunos grupos determinados, sino que se trata de desafíos de identificación más generales. Y otro de los datos, por ejemplo, es que existió un 15% de subregistro de nacimiento, ¿no? Entonces estamos hablando de brechas un poco más generalizadas. En el contexto de Haití, las funciones de registro civil y de identificación están básicamente distribuidas en tres instancias institucionales: las oficinas de registro civil, los archivos nacionales y la más importante y la que tiene una función de liderazgo y de responsabilidad mayor, que es la Oficina Nacional de Identificación, que se conoce como la ONI. En este entramado institucional, digamos que los pasos son: las personas registran los hechos vitales, nacimientos, matrimonios y defunciones en oficinas que se llaman del registro civil, pero que pueden estar ubicadas en diferentes instancias, digamos, edificios del gobierno municipal, en edificios de las secciones comunales, en algunos casos en registro hospitalario. El último decreto también habla de en iglesias, en templos vudú. Entonces digamos que son oficinas que se pueden localizar en diferentes instancias y que son las primeras que recopilan esta información sobre los hechos vitales. Una vez que esa información se registró en los libros de registro civil, el acopio de esa información y la validación de esa información se hace en los archivos nacionales, que después se convierten en la identidad encargada y responsable de emitir certificados validados de esas actas que se inscribieron inicialmente. Entonces, una vez que la persona registró sus datos en las oficinas de registro civil, si en el futuro necesita copias de esos certificados, ya no son esas oficinas las encargadas de emitirlos, sino los archivos nacionales, que se consideran como el acervo validado y legalmente reconocido de los registros civiles, de los archivos de registro civil. Y finalmente la Oficina Nacional de Identificación, que según el marco legal vigente igual tiene la función de supervisión y control de las oficinas de registro civil, es la encargada de emitir la credencial nacional de identificación, que es la identificación básica y más importante en el caso de Haití. El marco legal cambió un poco recientemente con un decreto ejecutivo que se aprobó en junio del 2020 y que, aunque establece instrumentos de identificación similares a los que ya había, sí introduce algunas reformas que significaron un nuevo proceso de enrolamiento para la identificación por parte de la población. Ese decreto ejecutivo estableció dos herramientas básicas, bueno, en realidad 3 herramientas básicas de identificación. Por un lado, estableció la existencia de lo que se llama ahora certificado de nacimiento, que viene a reemplazar lo que antes se consideraba el acta de nacimiento, con un formato nuevo que emite la Oficina Nacional de Identificación. Además, la credencial de identificación nacional única, que vendría a ser esta SINU, y un número de identificación nacional único, que emite también la oficina y que se incorpora desde el nacimiento en este certificado que se le emite a las personas. Y ese número de identificación las personas lo mantienen a lo largo de toda su vida. La credencial de identificación se emite a partir de los 18 años, que es la mayoría de edad legal en Haití. Y este decreto recupera la idea que ya existía en el marco legal anterior de que la identificación de todas las personas residentes en el territorio de Haití es obligatoria. Y además de que significó este enrolamiento masivo para la emisión de este nuevo formato de documento de identificación, el decreto establece una multa para las personas a las que se les en el espacio público se les solicite identificarse a sí mismas y no porten una credencial de identificación. En términos, y esto es un poco para entender el contexto de la identificación en general y los marcos legales que regulan esta identificación. En términos más específicos de los mecanismos que existen en el país para rectificar información, en términos generales, no existe un procedimiento legal que sea, con excepción de una última modificación en el decreto del 2020, no existen mecanismos que se dirijan específicamente al reconocimiento legal de la identidad de género como tal. Entonces, existen procedimientos de cambio de nombre. En todos los casos, a través de la vía judicial, se requiere ir ante un tribunal a solicitar ese cambio, pero no se concibe como que las personas puedan ir voluntariamente solo a petición de parte a cambiar el nombre. 2 de las causales que se manejan en el Código Civil sobre cambio de nombre son muy específicas y son en casos de reconocimiento de una persona, reconocimiento paterno de paternidad sobre una persona, entonces cambia su apellido, por ejemplo, o en el caso de que una persona sea adoptada y entonces decida cambiar su nombre, ¿no? Fuera de esas dos causales muy específicas, existen 2 casos que son juicios rectificativos cuando la persona puede demostrar ante el tribunal que hubo un error material, ortográfico, en el momento de la inscripción por parte del funcionario del registro civil, y entonces en ese caso se permite que exista un cambio. Este también se trataría como de un asunto muy específico. Y después existe otro mecanismo, que es este que se llama como juicio relacionado con la identidad, que se trata de casos en los que las personas, y este es el que se podría interpretar quizás como el más cercano al ámbito o a lo que se podría interpretar muy ampliamente como reconocimiento de la identidad de género, que es casos en los que las personas pueden demostrar con documentación o con testigos que en el ámbito social utilizan un nombre diferente al que aparece en sus documentos de identidad. Y entonces, lo que hace el juicio es facilitarles el reconocimiento de que no poseen doble identidad, es decir, que no están incumpliendo la ley, no están incurriendo en un delito, sino que la persona que está registrada con un nombre específico en sus documentos de identificación y en sus actas de registro civil es la misma que socialmente utiliza ese nombre. Entonces la sentencia no anula la identidad original de la persona, o sea, no rectifica por completo los datos, sino que solamente establece algo así como que la persona legalmente, aunque se llama de una manera, es conocida como con otro nombre. Y para esto la persona tiene en teoría que demostrar con documentación, con testigos, de diferentes maneras, que socialmente ha utilizado otro nombre. Aunque este mecanismo existe, no está contemplado como un mecanismo que podrían utilizar las personas trans, no está legalmente destinado específicamente a ese ámbito, y en las conversaciones que yo he tenido con personas de la sociedad civil, con activistas, con miembros de organizaciones LGBTI, no se interpreta este mecanismo como un canal a través del cual la gente puede acceder al reconocimiento de su identidad de género, y también como que se reconoce que mucha gente utiliza con otros fines estos mecanismos, personas que tienen antecedentes penales, digamos, como que se hace un uso a veces indebido de estos mecanismos, pero en general no se interpreta como una vía que utilicen las personas trans para lograr documentos de identificación que reflejen su identidad de género. En términos del cambio de imagen, no hay disposiciones normativas o legales específicas sobre esta materia, al menos yo no las he encontrado en el marco normativo que he revisado, y desde la sociedad civil tampoco se me ha mencionado que esto sea algo que está legalmente establecido, pero en la práctica sí las personas han logrado conseguir algunas documentaciones de identificación donde se les ha permitido tomarse la fotografía con expresión de género, y estas incluyen sobre todo sus credenciales de identificación, la SIN, pero también licencias de conducir, y en algunos casos, aunque esto es más difícil, el pasaporte. Entonces esto sí se ha logrado, aunque no tiene un sustento normativo específico, sino que en la práctica las personas que se han acercado a hacer este tipo de documentación, en algunos casos han logrado que se les tome la fotografía con la expresión de género. Y en términos del cambio de sexo, la jurisprudencia anterior a 2020 establecía casos, esto es bastante similar a lo que ocurre con el cambio de nombre, establecía casos específicos en los que la mención del sexo en los documentos registrales se podía modificar, pero tenía que ver también con errores materiales, con errores por parte del oficial de registro civil que hubiese inscrito el nacimiento, por ejemplo, y se hubiese equivocado, por ejemplo, en la jurisprudencia hay un caso de una persona que logró cambiar este dato, pero porque todas las otras cuestiones alrededor de su inscripción indicaban que su sexo era masculino y se le había escrito sexo femenino, entonces se pudo comprobar de esa manera, pero no se trata otra vez, de un mecanismo, o no se trataba en esa jurisprudencia de un mecanismo orientado al reconocimiento de la identidad de género, sino a corregir errores, digamos, de inscripción. El decreto de 2020 introdujo una disposición en su artículo 5 que sí menciona una cuestión que podría interpretarse como una apertura al reconocimiento de las personas trans, porque dice que toda persona que haya atravesado, y el concepto que se utiliza es un cambio morfológico, puede dirigirse dentro de los 2 meses posteriores a que se haya producido ese cambio a las oficinas, a la Oficina de Identificación Nacional de Identificación, a solicitar que se rectifiquen esos datos. No hay ninguna precisión en esa norma que hable sobre las personas trans, que hable sobre identidad de género. Tampoco se especifica muy bien a qué se refiere la legislación con este concepto de cambio morfológico. Entonces, la interpretación puede ser variada y es un poco vaga en esos términos sobre qué implica esta cuestión del cambio morfológico y cómo se traduciría eso en la rectificación de los documentos. En la experiencia de las personas de registro civil, de sociedad civil, perdón, con las que hablé, me comentaban que no se termina de entender si esto del cambio morfológico requeriría que la persona demuestre que ha atravesado tratamientos de reafirmación sexual, por ejemplo, cirugías o tratamientos hormonales, o si simplemente la persona demuestra con su expresión de género su identidad, esto ya se considera como un cambio morfológico. No queda claro hoy en día, porque además la implementación de ese nuevo decreto, y específicamente de esta disposición del artículo 5º, tampoco ha sido muy clara ni sistemática. Pero sí, desde las organizaciones de la sociedad civil, existen casos, al menos 2 mujeres trans, que han logrado conseguir una credencial de identificación donde cambiaron el marcador de sexo apoyando y sustentando su solicitud en ese artículo. La cuestión es que hoy en día, si ese cambio morfológico requiere tratamientos de reafirmación sexual, hoy en día estos tratamientos no están disponibles en Haití. La gente no puede acceder a cirugías o a tratamientos hormonales. De hecho, muchas de las personas viajan a otros países para hacer este tipo de tratamientos, o, por ejemplo, muchas organizaciones buscan hormonas y facilitar el acceso a los tratamientos hormonales comprando los insumos en República Dominicana. Entonces, el acceso a esos tratamientos no es fácil en el país. Entonces, existe también la preocupación de a qué se refiere con ese cambio morfológico y qué implica, ¿no? Y finalmente, en términos del marco legal, otra norma que también se aprobó por decreto ejecutivo en 2020 es, y perdón porque ahí hay un error en la presentación, es el Código Penal, no el Código Civil, que se aprobó en 2020, que establece sanciones por discriminación. Y entre las variables de la discriminación se menciona el sexo, la apariencia física y la orientación sexual. No se menciona específicamente la identidad de género, pero se establece que en caso de que se compruebe discriminación por esos factores, existen sanciones tanto que van de 1 a 2 años de prisión, como también al pago de multas. Entonces tanto esta modificación del Código Penal como la inclusión de esta idea del cambio morfológico en la nueva ley de identificación generaron muchas reacciones adversas de determinados grupos al interior de Haití, pero la sociedad civil incluso con estas modificaciones, no interpreta que exista hoy un marco legal que sustente de manera sólida el reconocimiento de la identidad de género en el país. Digamos que en la actualidad de Haití hoy, el hecho de que el sistema de identificación no esté completamente integrado, es decir, que la información de registro civil no necesariamente esté completamente articulada con la información de identificación. El hecho de que la trazabilidad del registro de una persona sea difícil, por ejemplo, muchas personas cuyo nacimiento sí fue registrado, nunca pueden recuperar sus documentos de identificación originales porque no se encuentran en los archivos. entonces es muy difícil esta trazabilidad. Y la integridad del sistema, digamos, hay varios como huecos por donde se pueden colar algunas prácticas informales al interior del sistema. Estas cuestiones que se podrían interpretar como debilidades del sistema se terminan convirtiendo en oportunidades y han generado situaciones en las que las personas trans han logrado obtener documentos que reflejan su identidad de género autopercibida. Entre otras cosas, por ejemplo, personas que, aunque tienen documentos o aunque su nacimiento fue originalmente registrado, se acercan a las oficinas y dicen que nunca se les registró su nacimiento, y entonces hacen una declaración tardía, y en esa declaración tardía manifiestan la información que refleje su identidad de género autopercibida y no la que se les asignó al nacer. Y entonces obtienen documentación que refleja su identidad de género autopercibida, pero no basándose en un sustento legal, sino en estas como debilidades del sistema. Y también me comentaban que otra cuestión que ocurre es que a veces las personas se dirigen a alguna oficina de identificación a solicitar sus documentos, y realizando pagos irregulares a los funcionarios, o digamos, aprovechándose de esas debilidades del sistema, terminan obteniendo documentación que refleja su identidad de género autopercibida porque no se les solicita toda la documentación de base, como por ejemplo su acta de nacimiento original, entonces se les toma la información de manera declarativa y eso se refleja en su documento de identidad. En parte, el enrolamiento masivo que ocurrió en 2020 a raíz de este decreto que establecía una nueva credencial de identificación y un nuevo número de identificación, abrió esta oportunidad de que todo el mundo tuviera que ir a solicitar una nueva documentación. Y en esa oportunidad, la Oficina Nacional de Identificación se coordinó con organizaciones aliadas junto con organizaciones LGBTI, y entonces lo que se hizo fue que funcionarios de la Oficina Nacional de Identificación se ubicaran en las oficinas de estas organizaciones aliadas para generar que las personas de la comunidad LGBTI se sintieran más seguras en un ámbito más cómodo para hacer sus trámites de identificación, porque muchas personas no querían ir a las oficinas tradicionales, porque no se sentían cómodas, no se sentían seguras, digamos, existía un miedo de acudir por el tratamiento que recibían en esas oficinas, por la violencia, de estar, digamos, en una oficina pública donde hay mucha gente. Entonces, con esta cooperación que se hizo y con esta coordinación que se hizo entre la Oficina Nacional de Identificación y estas organizaciones aliadas, se logró que más gente de la comunidad LGBTI fuera a solicitar su documento. Y en ese ámbito de enrolamiento masivo también ocurrió que es un poco una situación de caso a caso, un poco al azar, un poco de suerte, que hubo personas que a través de estos mecanismos que yo comentaba, de debilidades del sistema que se convierten en oportunidades, lograron obtener documentación que reflejara su identidad autopercibida. El problema es que los cambios en alguna documentación no necesariamente se reflejan en las otras. Entonces hay personas que terminan teniendo un acta de nacimiento con unos datos, una credencial de identificación con otros datos, y por ende un pasaporte que, si está basado en el acta de nacimiento, no se corresponde con su credencial de identificación, y eso también los pone en una situación de inseguridad jurídica y de posibilidad de enfrentarse a sanciones, ¿no? Pero entonces, como hay poca trazabilidad y poca integración entre la información de identificación en el país, se generan estas situaciones. Y en relación a las diferentes campos de información que se pueden cambiar en la documentación, nos comentaban, por ejemplo, que a diferencia de lo que pasa en otros países de la región, donde el campo del sexo o del género suele ser el más difícil de modificar, en el caso de Haití, como el decreto incluye esta idea del cambio morfológico, hubo personas que, sustentando su solicitud en ese artículo, lograron obtener una credencial de identificación donde el campo del sexo está cambiado, pero no se les permitió cambiar el nombre, por ejemplo. Entonces, en términos generales, en el caso de Haití, como yo les comentaba, es un contexto en el que hay dificultades generales de identificación en el país, entonces las brechas no afectan solamente a las personas trans, sino que es un desafío más general. no existe una vía administrativa legalmente sustentada para el reconocimiento de la identidad de género. Digamos que es todo un poco casuístico, caso a caso, muy por el azar, muy por las debilidades del sistema, y a diferencia de lo que ocurre en otros países de la región, donde cuando no existe un marco legal favorable, lo que se hace es activar la vía del litigio estratégico. En el caso de Haití, en las conversaciones que yo tuve con la sociedad civil, no se percibe la vía judicial y el litigio estratégico como una acción viable o frecuente o como algo que forme parte del repertorio de incidencia de la sociedad civil en estos términos. También mi sensación es que la incidencia por parte de la sociedad civil en este momento pasa por otras prioridades, como más urgentes, por abordar necesidades más urgentes de la población trans, como son el acceso a la salud o la posibilidad del acceso a la vivienda o del establecimiento de casas de acogida. Entonces, en términos de sus estrategias de incidencia política, el reconocimiento legal de la identidad de género no forma parte todavía de una prioridad o de una acción articulada o coordinada. Y los casos exitosos que se me han presentado de personas que sí han logrado obtener estas identificaciones, como les comentaba, tiene más con el azar, tiene más que ver con el azar, con la suerte y con las debilidades del sistema, que con que haya un marco legal o normativo que lo establezca y lo permita. Y en este contexto, las posibles vías de incidencia que se podrían establecer... Sí.
Excuse me, Verónica. We are very short in time.
Okay, this is my last slide. This is the last one. Entonces, las únicas posibles vías sería promover el intercambio de prácticas y experiencias con otros países de la región. Las organizaciones de la sociedad civil están muy ávidas de poder intercambiar y conocer más sobre esto, y me hablan de que los recursos existentes a veces por la barrera del idioma se pueden complicar. Otra cuestión es fortalecer la capacitación de las organizaciones de la sociedad civil en el tema específico del reconocimiento legal de la identidad de género, sobre todo teniendo en cuenta el antecedente de la opinión consultiva. Y otra cosa sería explorar la posibilidad de reanudar la cooperación de la ONU y las organizaciones aliadas para abrir un espacio más seguro en el que las personas pudieran tramitar sus credenciales de identificación. Muchas gracias.
Thank you very much, Verónica. I would like just to say that we are hoping in the near future to expand the scope of this research exercise to other countries in the region. And now we have a panelist from the Inter-American Commission on Human Rights, the recently appointed rapporteur on the rights of LGBT persons. I would like to give the floor to Ms. Roberta Clarke. Roberta, please go ahead.
Thank you very much, Marcella, and good afternoon, Ambassador Adsett, my co-panelists, representatives from member states and civil society and human rights organizations from across the OAS system, but in particular from the Caribbean, participating in this dialogue. And I see that you all have been using the chat to share questions and commentary and guidance with each other. Wonderful to read it. It is an honor to participate in this webinar with you all. And in fact, it is my first as a rapporteur for LGBT issues within the Inter-American Commission for Human Rights. I want to start off by thanking Synergía Initiative for Human Rights, and in particular Stefano, and the Universal Civil Identity Program in the Americas for the invitation to me speak at this webinar. Of course, I have to thank the OAS for its continued commitment to improving the lives of LGBTI persons, as evidenced by programs such as PUICA. We've heard about that from Rebeca earlier this afternoon. And of course, I want to commend Synergía for its role as coordinator of the LGBTI plus Sex Worker Coalition, and the state of Canada for their work in the core group of states. Please know everyone here who is on the panel and also online in the audience that you can count on the LGBTI rapporteurship in support of your work. So I want to start off by saying that the legal and indeed socio-cultural recognition of gender identity is essential to ending exclusion and marginalization. And we believe that these guidelines must and can contribute to securing the autonomy, self-determination, and freedom of trans, non-binary, and gender diverse persons in the region. In this presentation, I have 10 minutes. I will address three considerations that flow from this advisory opinion. One, the foundational character of equality and non-discrimination to inter-American human rights law, and indeed international and national law protecting the rights of LGBTI persons. Secondly, I will address why the advisory opinion matters to all member states of the OAS, whether or not they accept the jurisdiction of the court, whether or not they have ratified the American Convention on Human Rights. And finally, I want to point practically to how civil registries can fulfill state obligations, including those that are contained in the advisory opinion. So starting off with equality and non-discrimination, we have to agree that the right to equality and non-discrimination are at the core of our regional human rights standards. And this is evidence in the text of the Charter of the OAS. It's evidence in the American Declaration on the Rights and Duties, they say of man, let's say of people, and the American Convention on Human Rights and the Inter-American Convention against all forms of discrimination. Indeed, the right to equality and non-discrimination in international human rights law are referred to as non-derogable. They cannot be breached under any circumstances. Equally fundamentally, and in a region like ours in the Caribbean, I say like ours because I come from the Caribbean, region scarred by a history of extreme discrimination, rights to equal treatment and equal protection of the law are embedded generally in Caribbean constitutions, at least in the CARICOM constitutions to which Westmin has referred. And so in a system that unites 35 diverse states, different kinds of jurisdictions, some civil law, some common law, equality and non-discrimination serve as a guiding compass that can help us navigate what you might call complex legal problems. This compass enables the evolution also of standards to protect the rights of historically excluded and silenced populations, such as LGBTI persons who have been absent from international law, but indeed also from national law. So the Inter-American Commission of Human Rights and the court are both playing a role in identifying and interpreting state obligations to protect, respect, and fulfill the rights of LGBTI persons on a basis of equality and non-discrimination. This necessarily, given the historical exclusion, is an iterative and evolutive process. In other words, it's evolving. And the more we understand the dimensions of marginalization and the impact on restricting human rights, the better we are all able to articulate with some specificity the state obligations to redress these harms. And that is exactly what the Inter-American Court's Advisory Opinion 2417 does. It articulates how the equality and non-discrimination guarantees are to be effected through the elaboration of practical and actionable standards for the protection of the right to identity by trans, non-binary, and gender-diverse persons. So why does the advisory opinion matter to all OAS member states, not just the ones who have accepted the jurisdiction of the court? I think we can say that the advisory opinion is a reminder that the law in general and international law specifically is often a reflection of those who have had access to and influence on the standard setting processes. And for too long, the diverse realities and life experiences of trans, non-binary, and gender diverse persons have been ignored and indeed, and still resisted. Those days must be over, must be over. Institutions entrusted with the promotion and protection of human rights have the obligation to effectively guarantee all rights to all human beings without discrimination. And this is the effect of the advisory opinion, which has permeated the entire OAS system as it relates to the recognition of gender identities. The Inter-American Commission has incorporated the opinion in its thematic reports, in its merit reports, in the press releases, and recommendations to states. And the OAS programs such as PUICA, which we've heard from earlier today, are supporting the implementation of the advisory opinion in member states. What, you may ask, is the value, applicability, and implications of the opinion for those states that do not recognize the authority of the court? And we have heard from Westmin already today that some member states have not ratified several inter-American legal instruments, and even fewer, especially from the Caribbean, recognize the authority of the court. However, the court's opinion provides guidance to all member states, not just those who accept its jurisdiction and recognize its authority, And the court has said itself, and I want to quote the court's words, the interpretation given to a provision of the convention through an advisory opinion provides to all the organs of the OAS member states, including those that are not parties to the convention, but have undertaken to respect human rights under the charter of the OAS and the Inter-American Democratic Charter. So it doesn't matter whether you've signed or ratified the American Convention or accepted or not accepted the jurisdiction of the court. What this opinion is saying is that the thinking, the guidance, the interpretation given by the court is highly persuasive, indeed even binding on all member states of the OAS, in particular when you're interpreting fundamental rights such as the right to equality and non-discrimination. So this effect of the court's opinion, this kind of expansive effect notwithstanding ratification status, is covered as well in the guidelines that are being launched today, and I do urge you to go and have a read of it, because that chapter will give you the language to articulate some of the response to perhaps opposition to the influence or the authority of the opinion. The guidelines also address in a very practical way the preventative nature of the advisory function, which is particularly relevant to the Caribbean states. And so the third area I want to look at is how the role of civil registries in ensuring equality in gender identity issues. For over the last 10 years, the Inter-American Human Rights System has brought attention to states' obligations to ensure that trans persons' identities be legally recognized as a first step, or as a step, certainly a foundational step, in addressing structural inequalities. In 2020, the Inter-American Commission published a report entitled Trans and Gender Diverse Persons and Their Social, Economic, Cultural, and Environmental Rights. I urge you to have a look at it if you haven't. And in this report, prepared only after consultations with the communities of trans, non-binary, and gender diverse persons around the region, the commission identified that the lack of access to social and legal recognition of their gender identities constitutes a major barrier to the enjoyment of basic human rights from an early stage. I don't need to tell you that. Many of you have been living that and resisting that and struggling within civil society movement for greater justice and social justice and equality. Having personal identification documents that do not coincide with their gender identities is a serious impediment to access to education, employment, social security, and health. And this marginalization results in short-sighted and highly discriminatory planning. So, for example, I understand during the COVID-19 pandemic, the Commission learned that a number of states in the region established gender-based measures that set up specific days of the week for the free mobility of women and men, with no specific protocols regarding trans, non-binary, and gender diverse persons. And this huge blind spots, resulted in incidents of violence and discrimination perpetrated by security forces, mostly against trans women whose identification documents did not correspond to their gender identities and expressions. So states must move to provide quick and simple legal mechanisms to enable all persons to register and or change, rectify or amend their names and other essential components of their identities, such as images or the reference to sex and gender. And so in this regard, civil registries have to be at the forefront of the efforts to recognize trans, non-binary, and gender diverse identities. And so given the binding nature of the opinion, which has been fully adopted by the Inter-American Commission in its reports and recommendations, civil registries have an obligation to ensure the effective application and observance of the guarantees, which are elaborated in the advisory opinion. So here are some practical things. Civil registries must, one, guarantee that the procedure for a person to achieve the amendment of their self-perceived identity is a single and comprehensive one that does not entail unreasonable burdens for the person. So, for example, in the chat, someone is saying in their country they've been told they have to file court proceedings. That's not simple, and that's quite a burdensome and time-consuming process. Civil registries must put in place a prompt procedure and adopt all possible measures to ensure that changes, corrections, or amendments to the records are kept confidential, really important. Civil registries must ensure that the procedure should be based solely on the free and informed consent of the applicant, without medical and or psychological or other certifications that could be unreasonable or pathologizing. As state actors, civil registries have the potential, indeed the duty, I would say, to positively impact the lives of trans, non-binary, and gender diverse persons in the region. So that's what we're here about, and that's what this launch of this guidance advances. I want to close by congratulating Universal Civil Identity Program in the Americas and Synergía for this elaboration and all of the work that informed this elaboration of the implementation guidelines of the advisory opinion. At the Commission, we are committed to a strong relationship with civil society and, of course, with member states. And I expect that our colleagues from the Caribbean, United Caribbean Trans Network, and all civil society organizations led by trans women, trans men, non-binary, and gender diverse persons to be engaged with us so that the work of the Commission has the needed impact to advance equality, non-discrimination, and social justice. In closing, I want to leave with the words of Justice Rampersad from Trinidad and Tobago, from the case of Jason Jones against the Attorney General. And that was the case challenging the criminalization of consensual same-sex intimacy between adults. And in that case, Justice Rampersad said this: "To this court, human dignity is a basic and inalienable right recognized worldwide in all democratic societies. Attached to that right is the concept of autonomy and the right of an individual to make decisions for herself or himself without any unreasonable intervention by the state." I think the judge is on the right course here. So thank you once again to organizers of this event for having me, and I look forward to the discussions.
Thank you very much, Roberta. Now, we want to conclude by giving the floor to a representative of the Caribbean Trans Civil Society, who is also the executive director of UC Trans, Alexus DeMarco, executive director of United Caribbean Trans Network. Thank you very much, Alexus. The floor is yours.
Thank you so much. It's good to be a part of this forum today, representing the United Caribbean Trans Network. It's a network of trans citizens made up through the Caribbean region. Today, we're talking about gender identity recognition, and to add to this conversation, what UC Trans is doing is we have now drafted a regional advocacy framework as it relates to this issue. So the regional advocacy strategy will focus on the development of the framework for trans-affirming policies and laws to promote the full inclusion of equal opportunity for transgender people in the Caribbean. The specific objective that UC Trans is going to achieve is that this advocacy strategy over a period of the next 5 years, we want to engage with governments to commit to take steps to enact laws to implement policies that allow for gender legal recognition, which promotes the full inclusion of trans people as equal citizens. These laws and policies should provide a legal gender marker that allows a trans person to indicate a preferred gender, male or female, and or B, in addition to this, UC Trans is looking for a third gender or a gender neutral or non-binary option for their citizens. The strategy will be developed by UC Trans members and member states, trans citizens. The strategy will be developed also to allow for coordination advocacy efforts geared at securing legal gender recognition for UC Trans and its members in different countries. The regional context of all this is that trans people in the Caribbean are adversely affected by the absence of legal gender recognition. There is little evidence and any legislative policy framework that allow for legal gender recognition in the Caribbean. In UC Trans member countries, trans persons are largely unable to change their gender markers on identifying documents, such as driver's license, birth certificates, and passport. This inability to change gender markers make it increasingly difficult for trans people to access certain services, secure employment, attend schools, to conduct everyday business transactions, such as opening bank accounts. There are no laws that recognize the third gender. National measurement tools such as the census, demographic, and health surveys does not recognize or capture the data relating to the gender identity of trans people. The inability of trans people to legally change their gender marker contributes to the isolation and the invisibilization of trans citizens within our region and those who migrate there. We have a strategic approach to this and core activities that we are planning to do. The regional advocacy strategy that we are about to implement will grow out of the recognition that trans people in the region have to live their lives with dignity and the need to be legally recognized in accordance with their own deeply felt internal individual experience. Legal gender recognition will help alleviate some of the associated challenges that trans people in the Caribbean have in ongoing daily recruits of their lives. Our strategy for this is that UC Trans will advocate, and through our advocation, we will engage with advocacy for legal gender recognition. By one, we need to be able to map out and engaging our stakeholders. We need to identify the opponents and develop a plan that will combat and that will also respond to the opponents' questions or their concerns as it relates to gender identity. We want to manage risk and uncertainties because doing this work, there are some risks involved, especially identifying and advocating for gender recognition as a trans citizen. One, we want to continue conducting our monitoring and evaluation skills as it relates to this. We also have a strategy of connecting stakeholders in the trans community and across the region. This is very important to create this unified front as it relates to advocating for the needs of trans citizens. This connection includes the Department of Legal Affairs, Social Services, the Ministry of Health, the OAS, and definitely our CARICOM leaders. CARICOM sits at a higher level and makes several decisions on behalf of states. Also engaging with the OAS, which we have been doing at UC Trans, allowing our voices to be heard on an international platform, informing our decision makers and our gatekeepers of the violations of no right to gender identity. UC Trans has already conducted research as it relates to how many trans citizens in the Caribbean does not have access to an identity. Many trans citizens are still stateless. Many trans citizens still live without an identity. So in our research, we will disseminate research on other issues affecting trans persons in the region, providing updates on key legal developments and best practices as it relates to gender identity recognition. We do welcome the new policy from Suriname. However, we do not welcome it with its stipulations that a trans person must undergo sex reassignment surgery in order to receive the identity that he or she deserves. We welcome the opinion, however, we do not welcome the fact that one must be able, who is of a social economic background, unable to afford these mortifying surgeries or self-defining surgeries in order to claim their self, to identify and their self to their own identity. We would like to work with our decision makers here at UC Trans, and we would like to inform them that it does not take surgery in order to identify as a trans citizen in our regions. We want to recommend that we engage more thoroughly with our decision makers and our gatekeepers. Our recommendation to you on this panel and to you watching by television, by you watching by Zoom, we want to recommend that you take time to learn the difference between sexual orientation and gender identity, and to stand with us as it relates to us having a place, having a right to identity, which is not our asking, but it's our right as citizens to have a right to identity. Thank you.
Thank you very much, Alexus. And now next, we want to offer the opportunity to ask just a couple of questions because we have up almost all the time available and we don't want to go further. So please, if you want to ask any question, raise your hand. Well, it seems that it was quite clear. The panelist was very brilliant. So, Stefano, if you want to give some closing remarks.
Thanks, Marcelo. Maybe I can say something, and if in the meanwhile somebody has some question or comment, those are welcome. I have a few, and I obviously didn't step in because I knew that I had this opportunity. First of all, I would like to say and to share, and here I'm just going to sort of like do a virtual launch of the guidelines. So we have the guidelines in French, and these are going to be available, and then also in English. These are going to be available soon on the. Sorry. Are going to be available soon on the website of Synergía, and then we will share them also with the office, with PUICA, and so they will be available also on the website of the OAS. So yeah, just a quick formal launch of the guidelines, finally also available in English and in French. Perhaps, and here I would like to again thank the Canadian mission to the OAS for having given the opportunity of really like being able to include CARICOM countries that have been outside. And again, I mean, the scope of these initial stages, as Marcelo said, has been limited, but we hope to be able to expand to more countries. I see that there is a comment from Caleb, so maybe I'm just going to give a few thoughts and then give the floor for the conversation. But I would like to start from saying and taking some words that Roberta said before, that the Advisory Opinion 24 offers practical and actionable points. So again, when we look at the landscape, then we saw, thanks Verónica and thanks Westmin for the analysis that you provided, that yeah, there are opportunities for partial implementation of the advisory opinion, but those are based on general legislation, provisions that were not meant for the recognition of gender identity. I think that we have to build on that, and obviously that's been the extreme value added of PUICA, being able to actually support civil registries to work towards the implementation of the advisory opinion, and specifically to those practical and actionable points. However, without a comprehensive legal framework, a clear legal framework is going to be very difficult. And this is where Alexus was pointing, because we see how then the norm and the realities are very different. There is a huge gap, a huge disconnect between the reality, the possibility of using loopholes, of using legislation that was meant for something else, and the lived reality of trans individuals. And so I think that those two processes have to come together. On the one hand, we need to use all the opportunities for cooperation, and this has been really like the opportunity that this work with PUICA has provided, the cooperation between a program of the OAS that offers support and technical cooperation to civil registries, and bringing in the contribution of civil society. But then on the long term, we need to really look at legislative change, because that's the only way to get to a sustainable and really actionable change in the lived reality of trans person in the whole hemisphere. I would want to say, and I will close by saying that I hope that again we had to make a selection, and we selected first the Clarke countries, as Marcelo was saying before, but I really hope that this is just a very beginning of a broader engagement in the CARICOM countries. We hope that we can cover the whole of the CARICOM countries and precisely look at opportunities for that type of cooperation that hopefully will lead to more change in the lived reality of trans and non-binary individuals in the sub-region. So thank you very much. Marcelo, back to you, and I don't know if Caleb wanted to intervene. We can close with some remarks from participants. Thank you.
Thank you very much, Stefano. I think that Caleb lowered his hand, so I think, but Roberta is asking, and Caleb raised his hand again. So Roberta first, and then Caleb, I give you the floor. Roberta.
No, I just want to say thank you and ask for leave. As you know, we're in the internal sessions now, and they've resumed. So I just want to say thank you to everybody and ask for permission to go to the next meeting.
Thank you
Stefano,
very much,
can I get
Roberta.
permission? Okay. Thank you.
Thank you, Roberta. Thank you.
Thank you. We are glad to have you here. And Caleb, please go ahead.
I just wanted to make a few observations. Stefano, the quick assessment you did for the countries feels like foundational work that, in my mind, if I'm creating a wish list, it's an opportunity for further litigation work. I would hope that you would be think about litigation as a tool, and I say this within the context of Lawrence versus Texas in 2003 in the U.S., Northern Ireland versus Norris, the criminalization process in 1967 and 69 for Canada and the UK, and almost 50 years later, the decriminalization process for Belize. I make that point because while we have constitutions, we really don't have states to look after our interests unless we are at the policy table. The states, for me, are, while they speak a good game about the value of human rights in practice, they will ignore us, and we need to prepare to push back using the legitimate governance tools of the court. With that said, it's clear to me that there's an opportunity to collect case studies within the Commonwealth. I found we had the case of Ivana Paris Simpson in Suriname, but I'm sure there are other cases out there to look at, to learn lessons about asserting the rights of trans people in the Caribbean in particular, leveraging Commonwealth case study. So I'm throwing that at you as an opportunity for further documentation. With that said, it's clear to me that there's also an opportunity to do some outreach work with the civil registry. For Belize, you would do the outreach work with the Solgen, who is primarily responsible for overseeing our civil registry. I'm tabling that to you, Stefano, to see if you will build on this documentation discussion we have to further strengthen the dialogue around action for the gender marker. We are in the middle of discussing taking the EOD back to Parliament. There's no time like now to add this legal recognition piece. Stefano, I love your smile, Marcelo. I love your smile, but I'm putting a full plate on the table for you to think about, and I'm finished.
Thank you, David. To our wonderful panelists, and to thank Government for giving us this opportunity to advance human rights in the Caribbean region. And I want to thank everybody that participated in this work. We hope you more important research.
I believe, Marcelo, your voice was breaking a little bit, so maybe people didn't get. I'm afraid we didn't get you. Perhaps if there are no final questions, I don't know if any panelists may have some final remark or messages. Otherwise, I believe Marcelo was saying that we can close the webinar.
I'd just like to say a final message.
Yes, please.
Before we go, it is very important and it's imperative that we begin to understand the lived realities of trans citizens in our Caribbean region. Yes, Latin America may have advanced and they may have their situations and their issues, but the way we engage with our decision makers and our gatekeepers and diplomacy is very important to get this agenda moved forward. The diplomacy level for trans citizens to even have access in that space is denied. And I don't take it for granted anytime I'm allowed to be in that space with decision makers and gatekeepers to be able to share the lived reality of my community. The issue is they have not yet grasped the understanding of the difference of sexual orientation versus gender identity. So there must be a vast training for these decision makers and gatekeepers, even within our own community, our LGBTI community and allies. They still haven't grasped that there is a vast difference between one's sexual orientation and gender identity. So for us at UC Trans, it's very important and imperative that we do get this message out, that our existence matter and that we will not be erased. And that's what's happening through these referendums, through women's groups, through surf and turfs. We are combated with these oppositions. But I just want to let you know to stand with us as we try to fight for the pathway to gender identity recognition in the Caribbean region, and not through pathologization, not through a doctor writing that, yes, this person has been known to be XYZ for many years, or they must have gender affirming surgery in order to get the gender marker. So that's one of the things I want to reiterate, and I want you to stand with us and connect us to those decision makers, create spaces and forums where we can speak for ourselves. The issue is we don't even have access to healthcare as trans citizens. So most of our community is saying, how are we going to gender identity recognition without even having basic hormones? But I say to them, this is intersectional. All of these things will come together, and when we fight for one, we're going to fight for all. Thank you.
Thank you, Alexus. There is no better way to close. And just to reiterate that the beauty of the work that we've been able to do with PUICA, I'm talking from civil society, has been precisely that, to create those synergies and that momentum. And therefore, it was very important for us to start this process with Caribbean countries. But nothing else to add to what you say and to your plea. Thank you, and have a good afternoon, everybody. Thank you very much.